open yourself up to discrimination. An example of that on the next slide is a firm of solicitors who should know better, but they said they were going to reject all applications from outside the EEA area on the grounds it would be difficult for such candidates to obtain work permits. So it was held in that case that there wasn't sufficient justification because there had been no consideration of individual cases. It was a broad sweep where they pretty much got rid of all applications from EEA applicants, and that, of course, was discriminatory. So just pausing there, I want to do a quick poll before we move on to health issues. You'll see on the screen in front of you a poll. Can you ask employees about their health in application forms? So if you could vote on that, it'd be really interesting to see your responses. Okay, so the majority of you broadcast the results. So 68% and 69% say no, and you don't win a prize, unfortunately, but you do win my best wishes. Because on the next slide, you'll see the you'll see the answer to this. Section 60 of the Equality Act. This is something you really need to be aware of. You can't, except in specified situations, ask a job applicant about their health until they've either been offered a job or been included in a pool of successful candidates. So it's often tempting to ask someone about their health because you want to know, are they going to be a reliable employee? But just be aware that you're stepping into dangerous waters if you do so. There are specified situations on the next slide. I'm not going to read them all out, but in those circumstances there, if you, for example, are trying to monitor diversity, or you're trying to make reasonable adjustments to ensure that people aren't put in a substantial disadvantage in the recruitment process, then in those circumstances you can ask questions. But just be aware you need to certainly fulfill one of those criteria in order to do so, or you fall foul of Section 60. A particularly difficult area is asking people whether or not they are allowed to work in the UK. You can open yourself up to a civil or a civil penalty or a criminal offence if you knowingly employ an illegal worker. How do you ask that question? Well, on the next slide, you'll see if you, for example, put stringent demands on black job applicants or people you suspect who don't have the time to work, then you're probably going to open yourself up to a discrimination claim. If you want to ask those questions, and it's advisable that you do ask those questions, then my advice would be to impose that question universally, so not just to a particular set of job applicants. And there's a link that Liz is going to post now to the Home Office right to work advice. So read that policy, read that advice, and that will stand you in good stead. Just by way of, before we move on to criminal records and this section on what to consider, there's a poll there. Can you ask an employee about spent convictions for a cashier's job? So cashier's job, position of responsibility, handling cash. Can you ask an employee about their spent convictions? That's really interesting. So I'm going to stop it there. That's cast your vote. No time to phone a friend, I'm afraid. So nearly 60% of you say no. It's a really split result, and that's very interesting. On the next page, you'll see the answer, which is for most roles, you're only allowed to ask what are termed unspent cautions and convictions, so those which are still active. Just by way of an example, if someone's got a custodial sentence for 0 to 6 months, then that will remain on their active record, if you like, for 2 years. After that, it's a spent conviction. You can't ask about it. You can only ask about basic disclosure. And that's the form of the question you see there. Do you have any unspent convictions? That's what you'd put on the application form. There is an exception. If someone's working with children or vulnerable groups, then you can go in to the to spent convictions and go a bit deeper into their record, so you can see warnings, reprimands, that sort of thing. And you can get that from going to the disclosure and barring service, and you can either get a standard or enhanced report. But again, as I say, they need to be working with children or vulnerable groups in order for you to do that. Just finally, by way of warning, there's a data protection provision which allows candidates to see information held about them. So if you are interviewing someone and you put on their application form as you're interviewing them, not a chance, this person's a raving lunatic, which happened in a case I was involved in recently. That person can, under the Data Protection Act, get a copy of your notes relevant to them. So just be aware when you're in the organisation, so when you're part of the recruitment organisation in the company, always make responsible notes and ensure as part of your training that you're telling people to make notes responsibly, because this can be used particularly in discrimination claims. If you say, for example, this person is not what we're looking for, dodgy legs, which is another case I had. So just be aware of that right under the Data Protection Act. Finally, before we move on to questions and answers, I want to just flag up some future legal issues. I raise these now because it may be that you want to consider, when you're offering employment to people now, you want to consider these issues. So working time is a big one. There's a recent case which has held, I don't have time to go into it now, but perhaps it's time for or perhaps it's suitable for a further webinar in due course. Travelling to work, if you are, for example, a sales rep, or you are travelling to a particular office which is not your usual office, it's been held in some circumstances travelling to work can constitute working time. That's something probably you would want to address in the contract of employment from the outset. So as soon as you've recruited that person, address that issue with them. Equally, holiday pay, you've probably seen in the news that there's quite a lot of to do about holiday pay claims. Essentially what this boils down to is people saying, if they're on commission, for example, well, when I take my holiday, I only get my basic pay. Normally, if I wasn't on holiday, I would get my commission. Some road workers, for example, get a dirty hands bonus. So if they're laying tarmac on a road, they'll get a 20 quid shift, for example, for actually getting their hands dirty. When they're on holiday, they're not working, so they don't get that dirty hands bonus. They get their standard basic pay. And what some of the European European courts have said is that you should get your normal pay packet for normal hours worked. That's a very brief summary of saying holiday pay claims are on the increase. It's something you probably want to consider from the outset of employment, addressing with your new recruits. And in my view, many employers should think about setting some money aside for possible back claims. It's the sort of employment law equivalent to PPI claims at the moment. I'm involved in mass litigation, 3,000 claimants I'm representing at the moment for these holiday pay claims. So it's very sort of, it's a hot topic, something to be aware of from the outset. On the next slide, you'll see that my Chambers is putting on an annual employment law conference. This is a shameless plug for it. It's happening on the 9th of October 2015 at the Leeds Crown Plaza. Um, I'm talking on holiday pay in particular, in much more detail. We have a keynote speaker, which is Jason Galbraith Martin QC. He's recently joined our chambers. He'll be talking about unfair dismissal issues. We'll be talking about also TUPE and the 2014 amendments, restrictive covenants, and much more in depth about disability discrimination, the knowledge defence, workplace stress, all of those sorts of issues. So it's a full day if you want, or you can come along for half the day. It's going to be a much more comprehensive sort of review of those issues. So if you would like to come along to that, there's further information. Liz has just posted the link there. Go to the bottom of that page, and there's a link to a booking form there. Or just give Broadway House Chambers a ring, and we can book you onto that. So those are my details there. If you have any questions after today, that's my email address. Feel free to drop me an email. But for now, I will have a look at the screen. Yep, I'll have a look at the chat box and answer your questions. So Kathy, she's put hi there. There was recently a case where an advert was seen as discriminatory to Spanish employees as it requested English speakers. Could this become a major issue for recruiters? Just pausing while excuse me whilst I have a drink. Well, in many senses, yes, because it's segregating, or it's putting to one side a whole group of, or a whole nationality, if you like, and on the grounds of race, that could be seen as discriminatory. I suppose if English speakers were required for that role, it could be seen as a proportionate means of achieving a legitimate aim. So, for example, if an employee is required to converse with offices, elsewhere in England, and those offices were conversing in English, for example, and they weren't familiar with sort of the Spanish language, and an employee only spoke Spanish and very broken English, you can see the difficulty they may have in sort of fulfilling the role. So in those circumstances, I think the justification defence would come in, but certainly on the face of it, it would seem discriminatory. So I hope, Kathy, that answers your question. I've got a further question from Wendy Sanders. How would we stand if we had women's clothing concessions within a store? The person has to supervise the changing room. Obviously, a male supervisor could cause concern to customers. Could we specify women-only applicants? Well, I suppose that would be quite a complicated issue because on the one hand, you could have a male supervising the changing rooms if the changing rooms were sufficiently segregated. So if there was a sort of a full door there, the male couldn't see in and couldn't make women uncomfortable. On the justification defence, you'd probably struggle slightly because what you would have there is a situation in which a male applicant would be saying, well, there's no chance of me making anyone feel uncomfortable here. But on the other hand, I suppose if as a company you wanted to say to your customers, come along, try these clothes on, we've got a woman here who can sort of pop into the changing room and get you the next size if that doesn't fit, all of that sort of thing, then you could probably justify it. It's a very difficult one, and that's probably quite a vague answer, but I suppose you would have to monitor the specific circumstances of it. I should say, for all of that, that's not, none of that should really constitute legal advice and doesn't constitute legal advice. It's general advice, general information. If anyone requires specific advice on those sorts of situations, I'm more than happy to deal with that on a specific case-by-case basis. Go to your solicitors or your legal department, and I know there are solicitors on here which their contact details are there. Concilia, for example, they are very good at dealing with those sorts of issues. So go to them, and they can always pass to me those queries, and I'll deal with them. So that's all from me. Thank you very much.
Thank you, Adam. Brilliant. Lots of questions there that I'm not sure Adam's going to obviously have a chance to get through to, so he will have a look at those questions, or we get some resources, or maybe contact you direct with them. Thank you so much for listening today. Sorry about the awful start with the technical issues. Randomly, it did give a bridge halfway through the event, so hopefully some of you managed to catch up. Thanks for answering those polls. It would be great so we can get some advice and some interest with regards to sort of what webinars Adam will be running in the future for us. And that was absolutely brilliant. Thank you very much, and look forward to speaking to you all in the future. So thank you, everybody.